I'm Patricia Nelson. I'm an attorney here at Fish & Richardson, and I practice in the media and entertainment practice here in Boston. And I am with...
Hello, I'm Ike Williamson. I'm a principal at Fish & Richardson and located, as is Patricia, in our Boston office. We both do media and entertainment work, and we're delighted to be here.
So I'm going to start by just giving an overview of copyright law, which really is the foundation of ownership in the music that people create. Copyright vests upon creation, upon fixation of a work in a tangible medium of expression. Once you create a work and you fix it in some tangible medium of expression, you automatically have ownership in that copyright. It vests with the creator of the work. Copyright gives you, the law of copyright gives certain exclusive rights to the creator, the author, or the owner of the copyright. You have the right to reproduce the work, the right to distribute the work to the public. You have the right to create derivative works from that copyrighted work, and you have the right to perform and display the work publicly.
When you say tangible, in the music world, give us an example of a tangible.
It would be something that's recorded as opposed to perhaps just a impromptu live performance. So if you're sitting there at your piano and you're just fiddling with the keys and you come up with something and it's not fixed in any tangible medium of expression that can be perceived by somebody's eye or through a machine of some sort or a computer, then that is not fixed.
Of course, before the recording industry existed, music was still copyrighted, but then it was written bars and notes,
right,
and lyric.
Right.
When you say copyright vests from the moment it's in that tangible form, either in written form or in recorded form, what do you mean by copyright vests?
That the rights of copyright, the rights that I just described, immediately become the property of the person who has created that work.
Without doing anything further.
Without doing anything further, right, exactly.
And that's true in most
most situations, right, and in most countries. The one area where that is not true is if the work is considered to be a work made for hire, where it's a work that's specially commissioned, that fits one of 9 categories that are outlined in the Copyright Act, in the statute, and those include a translation, a contribution to a collective work, and some others, or if it's a work that's created by an employee specifically within the scope of their employment. So if somebody hires you, you're working for a company, or you're working for a film company, or you're working for a publisher, and they ask you to specifically write a book or write a magazine article or write some specific music, and that's actually part of your job, then the employer stands in the shoes of the actual creator, and it's a work made for hire.
One example in the music industry might be if you join an orchestra as a member, the Lionel Hampton Orchestra, often now, because they have a manager and they have legal advice, you'll sign a work for hire agreement that will say if you create music while you're a member of the Lionel Hampton Orchestra, or you contribute to a performance that's recorded of the Lionel Hampton Orchestra, the Lionel Hampton Orchestra owns all copyrights to your contributions while you're a member of the orchestra. That, of course, is part of the union contracts with all union symphonies, so that they'll get a copyright fee, the orchestra. The individual members, even though they may have created something, either in performance or contribution, if it's a collective work, they will only share in it because it's a work for hire with the symphony orchestra, as their union contract gives them rights to individual participation. So work for hire is really different. You lose your copyright formally by entering to those agreements.
And the Copyright Act recognizes kind of the serious nature of a work made for hire agreement. So if you're not an employee, if you're being commissioned, as Ike had described, you really have to have, the only way it can be a work for hire is if there is a written contract. And that contract has to specify that it is a work made for hire, and the contract generally has to be in place prior to the creation of the work. But it is something that companies or people who are seeking to own rights of copyright and tend to be in positions of power will tend to use in a lot of situations. And the other thing is usually these clauses in these contracts will say, this is a work for hire, and by the way, if it's not a work for hire, there's going to be language in that contract that says you grant and assign all your rights of copyright to us anyway. So if anybody is in that situation and they challenge whether under the copyright law it really does meet the test of a work made for hire, there's sort of a bootstrap approach, and this is something lawyers tend to make sure of, that the person who is purchasing or trying to obtain the ownership of those rights have them in any event.
You own that music, but you can lose your copyright by either not protecting it when others copy it, not completing the registration process, which you'll talk about, for instance, which gives you the right to sue others who infringe it, or you, without either knowing it or without good advice, sign a work for hire agreement, which divests you of your copyright, or enter into some other agreement, which many musicians have in the past, these publishing agreements, where it turns out you end up not owning the right to publish your music. So it's sort of like Eden. You're born, and everything's perfect when you're born. Once you've created your music, you own it. But there's so many ways to lose your innocence along the way, and sort of we view the lawyer's job is to make sure that if you lose your innocence, you're paid for it, and or at least you understand you've lost it along the way.
There's two different levels of copyright that you're dealing with in music. You're dealing with the copyright in the sound recording or the performance of the musical work, and you're dealing with the copyright in the actual composition of the work. So if you have people who are singer-songwriters and they write their own music and then they perform, they own both pieces, and what they generally do is they retain the rights in the composition, or as Ike said, they may assign them to a publishing company, and then they enter into a recording contract with a record company who has the right to make records of their performance, and that is a separate right. And what the record company then has to do is they enter into a recording contract with the artist, but then they have to go and obtain the publishing rights to perform the songs that are contained in the record. So there's two different levels there.
Copyright is a long exclusive privilege in those countries who are signatories to the Berne Convention, named after Bern, Switzerland, where it was created, and we came late to the convention under Ronald Reagan's presidency, but it has a very long term of copyright, life of the creator plus 70 years, and so you have a long time to that copyright. Obviously, at any time along the way, you can sell your copyright or exclusively license it or in some way transfer it to other parties. But you have a long life. Nevertheless, at some point, copyright ends. And so we often get questions. People are making a soundtrack, and they say, well, we don't have any problem, I assume, for our soundtrack because we're using nothing but public domain music. So we're going to use Beethoven, or we're going to use Leadbelly, or somebody who's no longer in copyright, either performance, because they're not going to play those performances, copy them, and the music itself is now in the public domain because their term of copyright is ended. That doesn't answer the question, because although the underlying music is in the public domain, a performance is separately copyrightable. What do you do next if you want to go to the Copyright Office?
Well, the United States is one of the only countries in the world that requires any formalities whatsoever. And I should correct myself, it doesn't actually require formalities, and that was a result of the Berne Convention. It used to be that you had to register your copyright in the United States to obtain the privileges of copyright. Once the United States signed on to the Berne Convention, which went into effect in 1978 in the United States, the United States had to drop the formal requirement of registration. So instead what it did is it offered a number of incentives to copyright owners to register the work. So again, you don't have to register it, you don't have to have a copyright notice on your work, but there are benefits to doing that, to making sure you have the little copyright notice anytime you release a copyrighted work into the world, and to registering your copyright with the Copyright Office. The main benefit is that you have to have a registration before you can infringe, or before you can sue anybody for infringement in the United States. So if you want to bring a lawsuit against somebody for infringing your work, you need to have that registration in place. It's really a good idea to register right away. If you register prior to an infringement taking place or within 3 months of publication of your work, you may be eligible to receive statutory damages in an infringement suit and attorney's fees, which is a really important thing when you're dealing with copyright infringement, because, as I'm sure everybody knows, that can get very expensive. So it's a very simple process. I recommend that anybody who's looking into this and interested go to the Copyright Office website, which is www.copyright.gov. There's fabulous forms on there. They're really easy to follow. They're very self-explanatory. You can register the copyright in your composition, as well as the copyright in your sound recording.
I don't really think you even need a lawyer. I mean, I think if you
don't.
go to the website and then you can get the forms, or you can either print them down or go to any government office and get them. The registration fees are what, $35?
Yeah, they're $35.
And you really don't need a lawyer, unless you're not an English speaker, because I don't think they're in multiple language forms.
No.
But other than that, that process is so crucial to establishing your ownership early on, not just, as Patricia says, because it's a prerequisite. You can't bring suit. Copyright litigation is, by the Copyright Act, limited to the federal courts. You can't sue in state courts, and there is no longer any state copyright in the United States. All is federal. All litigation is in the federal court. It's quite expensive. The good news about the Act is that if you're successful, the judge will award you attorney's fees, and in many cases may award you punitive damages, as she calls statutory damages, as opposed to actual damages. Your actual damages may not be very great at the point of infringement, but statutory damages can be substantial, and those are, again, determined by the court. Going back just for a moment, though, when I was talking about the two different copyrights that Patricia was outlining, the performance of a work and the actual creation of the work itself, that's what I think in common parlance we call covering. You know, we say so-and-so covered Little Richard's Bebop-a-Luma or whatever. So I think I've crossed musicians here, but that doesn't mean that Little Richard's lost his copyright. It means that somebody had to license whoever controls Little Richard's publishing rights in order for a different singer to cover that song. That may be a clearer example. So the result of which is that there are two different copyrights: the cover song singer's copyright in his or her performance, and the underlying copyright in the work. That doesn't mean now that the person who covered that song can go out and relicense anything other than their performance. They can't. They don't have the right to give somebody else the right to cover that creative music. The underlying music always belongs to the creator, and unfortunately in most instances into a publishing company owned by a record company, which an unrepresented musician has agreed to sign over their publishing rights when they enter into the record deal.
So if you write a song and you perform it and you've signed a record contract and it is out into the marketplace, anybody else can cover that song without having to get your special permission. This is something that's unique in music, the notion of a statutory license. So as long as you pay a fee to the musician or to the creator, the artist, the composer of the work, you can cover that song.